We'll begin as a subcommittee, so we can go ahead and start having hearings while we're waiting for some of the other members to filter in. And we'll begin with a public hearing, Senate Bill 901. Senator Henderson, please proceed when ready.
Thank you, Mr. Chairman and committee members. For the record, Mike Henderson, State Senator from the 3rd Senatorial District, presenting Senate Bill 901, age verification for online adult content. And so, a little background, we live in a digital age where the internet is literally at our fingertips through smartphones and other devices. While this technology is very helpful in many ways, it also creates new risks for our children, including early exposure to online pornography. Research shows that nearly 95% of youth are exposed to pornography online by the age of 17, with some exposed as early as age 5, which is almost staggering to me to think about that. But we have responsibility to protect minors from harmful online content. Senate Bill 901 ensures children do not have access to adult content and are protected through the age verification requirements. In 2023, Texas passed an age verification law that was challenged and ultimately upheld by the U.S. Supreme Court in June of 25. The language in Senate Bill 901 mirrors the framework used by Texas law. And I think there was one little piece in there in Texas that they had a heartburn in. We took that out of the bill, so we pretty much mirrored it up with that. Just to give you some background, I think our Attorney General Bailey began this process, and Attorney General Hanaway has continued with that process to try to do some of this through the Attorney General's office. Some clear provisions of it. It has a clear applicable standard. It's a straightforward bill. If a website contains more than 1/3 of content that qualifies as sexual material harmful to minors, as defined in the bill, the website must implement an age verification system that restricts access to individuals 18 or older. It has approved age verification methods in it. And then this is huge. I want to make sure that everybody up here understands. It has privacy protections. It is critically important to emphasize that any entity providing age verification services shall not, and I'll say it again, shall not retain any identifying information. This bill is designed to protect children while also safeguarding user privacy. So we're not creating a database out there that somebody can access at a later time. Limited liability for internet infrastructure providers. In other words, we're not going to hold Safari and Chrome or Google responsible for that, because they have search engines. We're not trying to cause any problems for people like that. This one has some enforcement and penalties. The Attorney General is responsible for enforcing the age verification requirements. If a website is found in violation of the law, the bill specifies some penalty provisions dealing with fines principally there with it. I'm just going to tell you this and make it real clear. I think some of this, because kids are getting on this at a younger age, and they all have one of these right here. They have one of these smartphones in them. We're distorting the way that young women look at young men, the way young men look at young women, what they think a healthy relationship is. And I think that we have a responsibility to do something to make sure that we take care of that. We hear of some of the things that are out there in the news, and we're thinking, how could this happen? And I think this is a good step in that direction. And Mr. Chairman, I'd be happy to answer any questions.
Questions for a bill sponsor from the committee? Seeing none, thank you for that presentation. In the interest of time, because I think we do have a fairly hard stop today, we'll be limiting testimony to 2 minutes for each individual, and I ask folks not to engage in collateral testimony if at all possible. With that, would the first witness in support please come forward and proceed when ready?
Good afternoon. My name is Timothy Faber. I just want to say I support this bill, not only Texas, but if I remember right, there's 19 or 20 other states who have similar laws. There's a similar bill in the House. It was voted unanimously out of committee last week, and it's in rules. And if we can protect our kids from numerous other things until they're 18, can't even get married until they're 18, can't join the Army until they're 18, and numerous other things, this just seems like a no-brainer yes. So I'd encourage everybody to vote for it.
Could you state the organization that you're with?
Oh, I'm sorry. Issachar.LLC.
All right, thank you. And make sure you fill out a witness card. And any questions for this witness from the committee? Hearing none. Thank you for being here. Next witness testify in support.
Hello, my name is Emily Van Shankoff, and I'm the director of the Missouri Children's Trust Fund, and we are a child abuse prevention foundation in the state of Missouri. We take a particular interest in the area of child sexual abuse, and we have one of the only child sexual abuse prevention grant programs in the nation. We're very proud of it. I'm here to highlight the impact that we are seeing in children because of the exposure to online pornography and the proliferation of online pornography. We believe that it is contributing it to a increased risk of perpetration of child sexual abuse. I think that it's quite clear. We don't need a bunch of research studies to tell us that pornography is bad for kids, but we do have lots of research on it. We also have extensive research that is now beginning to show that children who view and look at online pornography are at increased risk of perpetrating problematic sexual behaviors, almost to the doubling the. So a child who's been exposed to violent pornography or exposed to pornography has double the risk of perpetrating problematic sexual behaviors. What we know about child sexual abuse is that nobody wakes up at the age of 35 and starts perpetrating and preying on children. These behaviors typically come from a disruption in healthy sexual development that happens in adolescence. It is critical that we don't do things and let things happen in our environment that increase risk for people to perpetrate child sexual abuse. It is no life for any human being, and these individuals create incredible harm. The damage that is caused by child sexual abuse, I think you all fully understand. It is everywhere in our society, and we have done so many things in the last few years to try to reduce risk for child sexual abuse that it is very scary to the Children's Trust Fund and to me that we have this condition that's occurring. Pornography and the children's exposure to it is increasing risk of problematic sexual behaviors and perpetration of child sexual abuse. I'm done. Thank you.
Thank you for that. Very succinct testimony. Any questions for this witness? Hearing none.
Thank you.
Thank you again for being here. Further witnesses in support?
Good morning, Chairman, members of the committee. My name's Mary Chant. I'm the CEO of the Missouri Coalition for Children. We would just like to go on record in support of Senate Bill 901 and thank the sponsor.
Thank you. Questions for this witness? Hearing none. Thank you again for being here. Further witnesses in support? Seeing none. Any witnesses here testify in opposition? Please proceed when ready.
Thank you, Mr. Chairman, members of the committee. My name is Arnie C. A.C. Dienoff, State Public Advocate. And I'm about protecting children, but I think the age verification is going way too far in this situation. I know that some people reached out to me. Some of these age verifications is currently in place, but there are some court cases that will make it to the Missouri Supreme Court. I feel confident. I believe in the First Amendment. I feel confident that our Missouri Supreme Court will invalidate these promulgated rules and regulations and state statute. Child access to adult website should not be taking place. The parents should know what their children are doing. They have ample opportunity through devices such as cell phones, Chromebooks, iPads, other electronic devices to restrict or prohibit their children from seeing certain sites. Now, I know that children at our public schools, I know a lot of school teachers are always finding children inside school while during school hours that are engaging in adult material, and they're finding ways, creative ways, to get around the security walls and the security fortitude that's provided by the school district and is supported by our Missouri Department of Elementary and Secondary Education. They're always going through those bounds, and there's always somebody who's getting in trouble for showing nudity or adult content in our public schools all throughout our state. Children have access to cable, direct TV, other sources of television. They have HBO. HBO shows nudity. There's a Playboy channel shows nudity. There's a lot of things that could be out there, but it has to be the parents who take responsibility and accountability for their children and make sure that those appropriate restrictions are there. That's my testimony, Mr. Chairman, so I have to oppose it. It's First Amendment, and I believe the courts are going to rule that it's invalidated and unconstitutional. Thank you, Mr. Chairman.
Questions for this witness from the committee? Yes, Senator, proceed.
So I appreciate your comments. I'm curious though, I've got a granddaughter who's on her iPad, and there are cartoons that are pornographic that are not rated, So if I set a setting for my granddaughter, or my son sets a setting for my granddaughter, and it's just kid friendly, sometimes there's workarounds. So it doesn't matter how much, I'm just saying, I'm a mom of 5. It doesn't matter sometimes how much I do to try to protect my kids on their devices. My 17-year-old is basically locked out still. So, just so you know. But it doesn't matter what you do, there's workarounds to that. So that's part of the concern. The burden shouldn't always be on the victim or those who are being, targeted. What are your thoughts on that?
I don't think children should be targeted. And if they're doing cartoons, shame on them. There has to be ethics and morals. Shame on them for producing that and giving it to that type of audience or those young children. But I'll tell you what, the kids at this public schools, they're smart. They're a lot smarter than we are. I can't pronounce it. There you go. Technologically advanced. I'll tell you what, kids are getting. I watch kids that are 2 and 3 getting their parents' cell phone, and they know how to open up this and open up that. They're wizards compared to you or I. No, don't take it personal, but these kids are finding ways to get around all these restrictions. There's adults that are trying to do business with certain things or certain websites, like, for example, novels that they want to have access to. And because of the age verification, they have to put their driver's license with their photo and their pertinent information, their home address, their age, not your social security anymore because it's a driver's license number. But they feel that that information is an invasion of their privacy, and that information, although Senator Henderson said that it should not be retained, you can't tell me that they're not going to retain it. I think they are going to retain it. They're going to use it for marketing purposes, and you're going to get more increased mail because they have your mailing address to mail you more marketing information. And so I think it's causing problems to adults. But you're right. Shame on those companies who are catering to 2 and 3-year-olds with pornography and sexual explicit cartoons. I mean, that's shameful.
It is shameful. And so what do we do to protect those kids that are being targeted? So you show your ID when you walk into, if you go and buy liquor, you show your ID. If you go in to buy a hemp or any of this other stuff, you show your ID. In order to bank, you have to show your ID. In order to board a plane, I have to show my ID.
To vote.
To vote, you have to, right?
Yeah.
So anyway, not to belabor the issue, but
I agree with you on that point, and I wish it all comes down to the mighty dollar, unfortunately. And I wish corporations in corporate America, I wish they would think before they start marketing to 2, 3, anybody under 18. I just, would they want their child or their grandchildren to be treated like that or marketed in that way? I mean, it's not appropriate.
thank you.
Further questions for this witness? Hearing, seeing none.
Thank you.
Thank you again for being here. Further witnesses in opposition? Seeing none. Any witnesses here for informational purposes only? Seeing none. Senator, do you have any closing remarks?
Thank you, Mr. Chairman and committee, for hearing the bill.
Thank you. That will conclude the public hearing on Senate Bill 901. We will next proceed to public hearing on Senate Bill 844. Senator Hough, please proceed when ready.
Okay. The bill? The substitute on the floor will be handwritten right here. Appreciate that. Members of the committee, Mr. Chairman, Lincoln Hough, serving the city of Springfield.
Senator, I'm not sure if your microphone is on.
Try it again.
Thank you.
Thank you, Mr. Chairman, members of the committee. Lincoln Hough, serving the district of Springfield, Senate District number 30. This before you, and I appreciate the time and consideration today, Senate Bill 844. The overview on this, it really seeks to address what's becoming a national shortage in commercial liability coverage for child-serving agencies like Missouri's foster care contractors that serve over, I believe, last count somewhere north of 4,000 of our foster kids in this state. What Senate Bill 844 does is that it would allow organizations contracting with the state for foster care, case management, or residential services to be covered under our legal expense fund. As you guys probably know, the legal expense fund pays for claims and judgments against state employees. and a number of private actors. Think of healthcare providers that are contracted, like with your county jails, and provide care in those instances. The LEF payments are actually approved by the Attorney General, so in my opinion, you've got a little bit of oversight there. But adding these contracted foster care agencies to the LEF, in my opinion, protects the stability of this foster care program and what is becoming an increasing shortage of the availability of that commercial liability coverage for those entities. So with that, I'm more than happy to answer any questions, and we'll see if we've got any witnesses here.
And the underlying purpose being the expansion of the greater availability of
Correct.
foster care.
Correct.
Yes, thank you for that presentation. Any
Sure.
questions for the bill sponsor from the committee? Hearing none. Thank you for that presentation. First witness
You bet.
in support. Please come forward and proceed when ready.
Good afternoon again, Chairman, members of the committee. My name's Mary Chant. I'm the CEO for the Missouri Coalition for Children. We would like to thank Senator Hough very much for sponsoring this bill. There is a liability insurance crisis that's impacting not only the Missouri but the United States as a whole, but foster care and foster service providing organizations in Missouri are being deeply impacted. Child and family serving organizations are the anchors to communities and critical partners in the delivery of services that support child and family well-being. Some of the organizations that would benefit from this legal expanse fund would be those who provide foster care recruitment, licensing, kinship, traditional and therapeutic foster care, prevention services to families with open child welfare cases, residential treatment, transitional living services, adoption, guardianship services, and more. Mission-driven, sustainable work requires good business practices, and we have to have insurance. What we are finding is that we have members that over the last 7 years who have had no claims have had their insurance rates jump between 59 and 169%. We have one organization whose insurance rates jumped, 627%, from $17,000 a year in annual premiums to over $127,000 a year. And again, the organizations that I'm citing have had no claims made on their liability insurances. We cannot risk manage our way out of this. There are several factors that are impacting the private insurance sector's unwillingness or inability to keep insuring or to keep rates reasonable. But what we are finding is if we do not fix this, we will have organizations that cannot serve children in the foster care or child welfare system. And we very much appreciate, again, Senator Hough's introduction of this bill.
Thank you for that testimony. Questions for this witness from the committee? Hearing none. Thank you for being here. Further witnesses testify in support. Please come forward. Make sure you fill out a witness card and proceed when ready.
Thank you, Mr. Chairman, members of the committee. Doug Nelson with Clarkson Nelson here today on behalf of Missouri Alliance for Children and Families to echo the previous witness's testimony and be brief, give you an idea of what our client has looked at in 2020, $190,000 for the insurance today, north of $650,000. That's for about 50% less coverage, and their deductible went from $25,000 to $250,000. So the only thing I'd leave you with, if these contract vendors who are good partners with the department do not do this work, ultimately another vendor picks that work up, and ultimately the state absorbs that work for having to hire more employees and obviously providing second injury fund expense for those state employees. With that, I'm happy to appreciate the sponsor bringing the bill and happy to answer any questions.
Questions for this witness from the committee? Hearing none. Thank you again for being here. Further witnesses testify in support.
Mr. Chairman, members of the committee, David Willis here on behalf of KVC Missouri. I want to echo the sentiments of those testifying before me. We're a multi-state foster care case manager and residential provider. We've been able to maintain coverage, but we've seen skyrocketing rates not only in Missouri but in the other states we operate in across the Midwest. So appreciate the sponsor bringing this bill.
Questions for this witness from the committee? Yes, proceed.
David, do you think some of that might be because of things that are happening in other states? Because I heard one of the witnesses say there weren't even claims, but their insurance went up 600%. Are there things going on nationally that are impacting Missouri?
I don't know that I'm qualified to
Okay.
speculate on that. I know that as we're talking to providers all over the country, I think we're seeing less and less carriers willing to even write these policies. I know anecdotally of one story here in Missouri where they sought quotes from like 16 or 17 different carriers and got one person willing to write the policy. And those rates were 3 or 4 times what they had been paying.
Okay, thank you.
Further questions for this witness? Hearing none. Thank you for being here. Further witnesses testify in support.
Mr. Chairman, members of the committee, David Winton here on behalf of Family Forward, which is one of the child welfare agencies that provides foster care case management in the St. Louis community, and Children's Permanency Partnership, which is the consortium over those agencies. We are probably the canary in the coal mine on this, so I think I can answer the question that you asked, Senator McCreary. So we have, I think, 2 claims over the last 10 years, and I think the claims are like $12,000 total. And so we went to our initial carrier for renewal. They sent us a non-renewal letter. And so we started scrambling and trying to get insurance. We got 17 denials. And then we finally got insurance on the 22nd try with carriers. And so what's happening right now nationwide is we started thinking about, well, what can we do? Can we, as Mary Chant talked about, can we risk manage our way out of this? Can we make it easier? And the answer is they're just getting out of this business. It is a very small business for large insurance carriers. It potentially carries exposure to them on an otherwise big, large book of business. And so we're just finding these folks are getting out of the business. This is not an issue of they're raising rates. It's an issue of they're just not writing these things.
Questions for this witness? Hearing none. Thank you for that
Thank you.
testimony. Further witnesses in support?
Thanks, Jordan.
Seeing no additional witnesses in support, any witnesses here in opposition?
For sure.
Proceed when ready.
Thank you once again, Mr. Chairman, members of the committee. My name is Arnie C. AC Dinoff, State Public Advocate. You know, I don't think that this bill, SB 844, is fair to our state legal fund. I believe it gives additional exposures, additional liability, and additional problems. There's more expense. As you all know, we are facing a crisis in Missouri. If you listen to the state auditor gave a very clear memo back in December that we have to cut $1 billion from fiscal year 2027, $1 billion from fiscal year 2028. Everyone has to have insurance, liability insurance. You drive a car here, you have to have liability insurance. You want to go to a doctor, you have to have liability insurance. I mean, I could talk about all the insurances, but this is just the cost of doing business. Yeah, we've all received rates. I received homeowner increases that are skyrocketed due to nothing to my avail. I've received auto insurance raises due to the amount of losses to storm damage throughout Missouri because it's a shared cost of the loss to the insurance corporations. So the same with these 403 designations. They're funded by donors. They do a lot of fundraising. They get a lot of state appropriations through the Department of Social Services. And so guess what? They may have to pay another 10% for insurance. That's the cost of doing business to run their profit. They do a noble job. They're saving children. They're trying to find homes for foster children. And I get it. But I don't see much benefit to this change because guess what? If we self-insure, you know, and there's a big catastrophic claim made against the state legal fund, then we could be up a creek because they're going to be coming to the Senate Appropriations Committee asking to bail out that fund. So I don't see the need in the change. And I'll sum it up, Mr. Chairman, with the fiscal note, which is very concerning. It's a creation of 3 additional full-time employees. Fiscal year 2027, it's going to see an increase of $738,000. Fiscal years 28 is $848,000, and fiscal year 29 is $846,000. We're going to bankrupt our state with all the programs and all the funding and tax credits. We're not going to have any money to run operations to take care of these foster kids. For those reasons, I do not support SB 844. Thank you.
Any questions for this witness from the committee? Hearing none. Thank you for being here. Further witnesses in opposition? Come forward and proceed when ready.
Thank you, Chairman. Thank you, Senators. Chandler Gregg on behalf of Missouri Association of Trial Attorneys. There are some real dangers in this bill, and to address your question, Senator Coleman, there are. So I'm sorry. I'm sorry. So to address the question that you asked, Senator, it is a known problem with these entities and their failure to protect children. There's a 2024 U.S. Senate Finance Committee report, in fact, titled Warehouses of Neglect, How Taxpayers Are Funding Abuse in Youth Facilities. This is an enormous problem across the country. And in this particular case, what you would be doing is burdening the state and taxpayers with the costs of negligence and recklessness that is committed. And I'm more in favor of reducing the likelihood of harm to these children than reducing their ability to recover from them. You heard from KVC. KVC recently established an enormous footprint in this state. So nothing about what's taking place in this state have prevented them from coming in and gobbling up others. So another problem that what we need are reforms that protect these individuals and these children from the abuses that they suffer at the hands of these organizations, whether it be from the caretakers or whether it be from other individuals that are likewise in the facilities. And a problem with imposing all of this on the state is it's going to disincentivize them from taking the appropriate safety precautions to make sure that individuals are protected. So I think there's good basis. I mean, I understand that there's a noble purpose behind this bill, but it comes with pretty significant dangers as well. Disincentivizing safety and burdening the state and taxpayers with the wrongs that are committed by these entities.
Thank you for that testimony. Questions for this witness? Yes, Senator Coleman.
I'm
please
sorry, I
proceed.
didn't catch your name.
Chandler Gregg. Sorry, I got yours wrong.
No, it's fine. No, I don't care. That's not my question. So I was then trying to decide, do I call you Chandler? No, that's rude. And then we had this little interlude, so sorry for the pause. What do you suggest people do if there's not a product for sale? Is MATA going to help subsidize a new product?
Well, it may be. You're saying if there's...
I'm saying the testimony that we've heard from witnesses is that this is no longer a product that is being sold, which is typically why these state funds come in, is when this is a place that there's a problem, the market isn't providing an insurance policy. So that's actually a backstop to make sure that people can get made whole. So what is MATA's position if there isn't a product being sold that would allow the business to continue to operate so that families can be made whole?
To my knowledge, I didn't hear from anyone who was unable to get insurance. That's just what I heard. KVC came in, they continue to be insured. They claim they didn't know whether this was a problem around the country when there's
That
a
wasn't their
Senate committee
testimony.
report.
I mean, that just factually wasn't what they said.
They said they couldn't speak to whether this was an issue around the country. That's what I heard.
Well, that's not what they said. What they said was they couldn't speak to why this was an issue around the country. She asked if there was any policy changes that had increased that. And he said, I don't know what policies around the country would be adding to it. But the testimony that I heard was that there were up to 20, the 22nd attempt to try to get a product, and that these products are not being offered anymore by the insurance companies. Now, we didn't have any testimony from the insurers yet, but MATA is saying, no, too bad you have to buy a product that's not for sale?
Well, as I understand it, there is a product for sale. I didn't hear from anyone who said they were unable to be insured. And KVC certainly didn't say they were unable to be insured when they came in and gobbled up a number of other facilities. What I will say is perhaps insurance reform is necessary on that issue. The insurance companies are making plenty of money.
But you didn't testify to any of the insurance policies that might have been adding to the hardness of getting coverage, right? It's okay. I'm frustrated because I think that MATA tends to come in and say, no, with no actual solution. So you're getting the heat of that.
But I think that's a continuation of what we have seen, and so whatever, it's fine. Thanks.
Yeah, that's fine. It's a significant issue, and really what we ought to be doing is making sure we're protecting the kids.
Well, that is a good trope that often works.
Well, it's not a trope. It's what I would hope takes place within our state and within our country.
Further questions from the committee for this witness?
And the issue is, what is the best solution for doing that?
No further questions appear to be coming from the committee.
Okay,
Thank you
Senator.
for that testimony. Further witnesses in opposition? Witnesses for informational purposes only. Please proceed when ready.
Very briefly, Mr. Chairman, Hampton Williams with the Missouri Insurance Coalition. To answer Senator McCreary's question, there wouldn't be a direct cross-subsidization between entities across states. Where you do see an issue is on reinsurance markets. And so the cost to reinsure those type of products do go up because there's not only a contraction among providers on those marketing the product in state, but also that reinsurance market has more risk. And this is not a Missouri-specific issue. It's nationwide. I was not intended on testifying on this today, but I'll be happy to put a letter and circulate it to the committee. The studies are that the expansion of civil liability for child sex assault claims are driving the costs on these products. And the statutes that are written broadly enough not to distinguish between good companies, good foster care, or bad actors, and kind of conflating the liability for both are driving the costs across the board. And the concern is that when people have to take individual risks to be a good actor, what they choose to do is not engage at all. And so when people can't afford the insurance products, they don't foster. And that's certainly not been the policy of the state or anything that we've tried to do for years. Certainly there are abuses. Those committing abuse need to be held accountable. But this is a serious concern because, in fact, yes, this market is contracting because the liability is too great to make insurance pools that are large enough to be able to help insure folks to continue this operation. I'll be happy to answer any questions.
Further questions for this witness? Hearing none. Thank you for that testimony. Any additional witnesses for informational purposes only? Proceed.
Mr. Chairman, members of the committee, I'm Jeremiah Morgan from the Missouri Attorney General's office. I'm the Deputy Attorney General there. I have responsibility for administering, on behalf of the Attorney General's office, the legal expense fund. And so I have some familiarity with that, how that works, as well as the provisions of it. And I'm happy to answer any questions. I will say I was involved in speaking to the increased costs and expenses, I was involved in a 2017 class action that was filed against the state involving foster care. And the administration or the alleged improper administration of psychotropic drugs and so forth for those in foster care. In that case, the state of Missouri paid in attorney's fees alone a little over $4 million. So I don't know if that contributed to that, but that was one case that we were involved in. So in terms of the legal expense fund, we have suggested in the House an addition or I don't want to say a cap on it, but a $1 million contribution that would come from the legal expense fund, as well as one other provision as well. So that was one thing at least the Attorney General's office offered by way of maybe compromise or by way of trying to make it make sense. It's consistent with all the other provisions in the legal expense fund chapter as well. So with that, I'm happy to answer any questions.
Questions for this witness? Yes, Senator, proceed.
My follow-up question is just, is that cap and accessibility similar to the other provisions that have been placed in law for the other classes of people who can apply?
Yes, it is.
Okay.
There's the first two or three in the legal expense fund, Chapter 105, 711, deal with employees of the state, and there's not a cap there in those provisions. But the ones after that, where it talks about contracting with the state and different things like that, they each of them have either a $500,000 or $1 million sort of legal expense fund cap.
And that's a per instance?
Yeah, for instance. Yeah.
Okay, thank you.
Further questions for this witness? Yes, Senator, proceed.
Not a lawyer, so bear with me. I I understand what we're trying to do, I think, but I also can see where this is a bit of a slippery slope, which is like there are a lot of contractors and businesses and you name it that are doing business with the state. So, like, how do we draw the line for, like, we're going to do it as it relates to foster kids, but we're not going to do it for other entities? So is there any kind of clarity in the law about, like vital service? You know, I'm trying to think this through, because I could see where we could start having more pieces of legislation like this, quite honestly.
Well, and to be clear, if you read through the Chapter 105, 711, the legal expense fund provisions, you will see a potpourri, if you will, of different activities, different entities, or different, things that are covered under the legal expense fund, which is an accumulation that's happened over years.
Mm-hmm.
So your point is an excellent one, and that is, you have to make a decision. It's not mine to make, it's yours to make legislatively, a policy decision. What will you subsidize, right? What is it? What's important for you to subsidize? And and that's how I would frame it, is sort of this $1 million or whatever it may be is, in a sense, a subsidy of this industry, depending upon if that's important and what level it's important. Again, as you look through the provisions of Chapter 105, you'll see a variety of different ones, and sometimes quite unique. You think, how did that get in there? Mm-hmm. It got in there because there was some issue that was brought up, and people felt like, from a policy standpoint, we ought to address this.
Mm-hmm. Yeah, and I appreciate that, and I will look at Chapter 105.711. I can't.
If you desire to get a good night's rest, that's the start of it. That's the start
actually. I think I had a hearing this morning on a bill where we heard some tragic testimony about the connections between child abuse and animal abuse and all of that. And, I think one of the issues with child abuse, childhood sexual abuse, everything under that umbrella, is as a society we're getting more comfortable talking about that. And so I think that it's always been happening, but now we're starting to, like, people are starting to reveal things that have happened to them. So I can also see where some of this is just, we're starting, like, we need to actually be doing what we can to protect kids and make sure kids stay safe. And I think as more and more survivors of childhood abuse come forward, we are going to see more claims.
Yeah.
So, very good.
Appreciate that.
Thanks.
Further questions for this witness? Hearing none. Thank you for being here. Any witnesses further to testify for informational purposes only? Seeing none. Senator, any closing remarks?
Appreciate your time.
Thank you, Senator. We will next proceed. That will end the public hearing for Senate Bill 844. We will next proceed to the public hearing for Senate Bill 1272. I will turn the committee over to Senator Coleman, since our vice chair appears to be close but not here.
Thank you, Mr. Chairman. We're ready to hear your Senate Bill 1052. Please proceed when ready.
No, you can have that.
1272. Yes. Yes, thank you, Madam Chair, members of the committee. Curtis Trent, representing Senate District 20. This is Senate Bill 1272, which the committee has heard before, on abusive website access litigation. There is a committee substitute, which has been distributed, and I will contain my brief remarks to the substance of the substitute. As you can see there in the summary, we are chaining together the three abusive website access bills, with 907 being the first in the chain. The substitute further modifies the definitions of access violation, resident of the state, particularly to remove the definition of public accommodation in the bill, because we want to focus on the Americans with Disability Act and not incidentally or accidentally create a public accommodation cause of action with this litigation or with this legislation. It further modifies the factors the court may consider in determining if litigation alleging any website access violation is abusive litigation, and removes the factor in determination for abusive litigation that the filing party or lawyer is a Missouri resident or licensed to practice law in Missouri. Corrects various references to factors and sanctions relating to representations to the court, and changes time frame to correct violation from 30 days to 90 days, and modifies rebuttable presumption. Adds language authorizing the Attorney General to intervene to bring action on behalf of Missouri residents or entities that are targets of abusive website access litigation, as well as to issue guidance on what constitutes such abusive litigation. Would be happy to answer any questions that the committee has.
Thank you, Senator. Any questions for the senator? Seeing none. First witness in support, please come forward. State your name.
Good afternoon, Madam Chair, members of the committee. Jared Hankinson, Vice President of Government Affairs with the Missouri Chamber of Commerce and Industry. I want to thank Senator Trent for bringing this legislation forward, and I think he summarized the substitute very well. I know the committee has heard testimony from my organization on this same legislation before. We'll just reiterate a few points. We saw what happens when this goes unaddressed in the state of Kansas. Dozens and dozens of businesses that were forced to close their doors, even more that faced tens of thousands, if not hundreds of thousands of dollars in abusive and targeted litigation costs, and we're happy to have an opportunity to address that possibility and prevent that from happening in the state of Missouri. We've heard from members, whether they're medium-sized manufacturers, whether they're small mom-and-pop coffee shops, that this is real and this is happening in the state of Missouri. Unfortunately, we weren't able to bring any of those businesses to testify with us today, but our membership is incredibly grateful for the action that has been taken here. We'll just re-emphasize with the committee that similar legislation in the House side did pass unanimously. It was the second bill that the House sent over to you all, and I'm happy to take any questions.
Thank you. I apologize to the committee. I didn't start my timer. You were probably under 1 minute, but because we've got the exec session coming up, I'm going to start that moving forward. So anyways, anybody have any questions for this witness? Seeing none, next witness in support, please come forward.
Thank you very much, Madam Vice Chairwoman, members of the committee. My name is Arnie C. A.C. Dinoff, State Public Advocate. You know, this is horrific that there's one person, a Florida lawyer with his uncle, that are preying on Missourians and a lot of other states across our country, shaking down small businesses. I testified in favor of a companion bills in the House Judiciary Committee, I believe it was Judiciary, where restaurants here in Jefferson City were being shaken down and scammed, and they were forced into signing a NDA, a non-disclosure act, and they had to pay out a lot of money to make these things go away. And when they thought they were done, the same lawyer made the same claims, saying that they didn't comply with ADA, Americans with Disabilities Act, on their website, even though there's no foolproof a website with Americans with Disabilities Act. This is a pure scam. It's for somebody trying to profit off of small businesses.
Thank you, Mr. Dinoff. Any
for
questions for this witness? Seeing none, next witness in support, please come forward. I didn't realize you had the timer going. Thanks. I'll leave it to you.
Stereo.
Go ahead.
Thank you, Madam Chair. Brad Jones with the State Director for the NFIB, and once again, we are very supportive of this legislation. We've had members that have called, and it's not a pretty story, so thank you. And I want to thank this committee for really getting on this bill, because first of all, nothing passes the House 149 to nothing. I'm still kind of, that's still kind of miraculous to me. So, but we're thrilled this thing is moving. So, thank you all very much.
I'm sure it'll get a lot of vetting on the floor of the Senate still. Any questions for this witness? Thank you, sir. Next witness in support.
Matthew Smith with Associated Industries of Missouri. Just want to go on record in support of this bill and appreciate all the work this committee's done on this extremely important issue for Missouri businesses.
Thank you. Any questions for this witness? Seeing none, next witness in support.
Thank Thank you, Madam Chair. Sam Panettiere on behalf of the Northland Regional Chamber of Commerce. We represent businesses across Clay and Platte County. Also like to go on record and support, I think the previous witnesses covered our testimony as well, so appreciate the sponsor.
Thank you, Mr. Panettiere. Any questions for this witness? Seeing none, next in support, please come forward.
Madam Chairwoman, Hampton Williams with the Missouri Insurance Coalition, testified in support of the bill. Thank you.
Any questions for this witness? Seeing none, next in support.
Madam Chair, members of the committee, Will Mars on behalf of the Branson Lakes Area Chamber of Commerce. Just want to go on record in support of this bill.
Thank you, Mr. Mars. Any questions for this witness? Seeing none, next witness in support, please come forward and proceed when ready. Going once, going twice. Anyone here in opposition? Anyone here for informational purposes only? Seeing none, Senator, do you have any concluding comments?
No concluding remarks. Thank you.
Thank you, Mr. Chairman. I'd like to hand the gavel back to you.
All right, now we will establish quorum. Mr. Secretary, would you please call the roll?
Chairman Trent. Here. Senators Gregory. Here. Burns. Carter. Coleman. McCreary. Here. And Weber.
Quorum having been established, I move that we go into executive session. Do I have a second? It's been seconded. All those in favor, please signify by saying aye. Any contrary, say no. The ayes appear to have it. The ayes do have it. We're in executive session. I next make a motion that we bring Senate Bill 907 before the committee. Do I have a second? It's been seconded. All those in favor signify by saying aye. Any opposed to the contrary? The ayes appear to have it. The ayes do have it. The bill is before the committee. There is a Senate committee substitute. It has been distributed, and I move for its adoption. It's been seconded, and I move for its adoption. This Senate committee substitute is the one that we just heard. It strings together 907 with 1154 and 1272. And makes the changes that we described in testimony just earlier in committee. Any question or any comments or discussion on the motion? Hearing none, all those in favor of adopting Senate Committee substitute for Senate Bill 907, please signify by saying aye. Any opposed to the contrary? The ayes appear to have it. The ayes do have it. You've adopted the Senate Committee substitute. I now move that Senate Committee substitute for Senate Bill 907, 1154, and 1272 be voted out of committee do pass. Any discussion? Hearing no discussion, Mr. Secretary, please call the roll.
Chairman Trent. Aye. Senators Gregory. Aye. Burns. Carter. Coleman. Aye. McCreary. Aye. And Weber. Aye.
By your vote of 6 ayes and 0 noes, you have voted do pass Senate Committee substitute for Senate Bill 907, 1154, and 1272. I next move that we bring before the committee Senate Bill 1310. Do I have a second? Second. It's been seconded. All those in favor, please signify by saying aye. Aye. Any opposed to the contrary? The ayes appear to have it. The ayes do have it. Senate Bill 1310 is before the committee. If everyone will recall, this was the suspension of the Medical Malpractice Joint Underwriting Association. I make a motion that the committee vote do pass Senate Bill 1310. Any discussion on the motion? Hearing none, Mr. Secretary, would you please call the roll? By your vote of 6 aye and 0 no, you have voted to pass Senate Bill 1310. With no further business coming before the Executive Committee, I vote that we exit executive session. Do I have a second? It's been seconded. All those in favor, please signify by saying aye. Any opposed or contrary, say no. The ayes appear to have it. The ayes do have it. We're out of executive session, and we'll now proceed to the public hearing on Senate Bill 1052. And I will turn the gavel over to Mr. Vice Chairman.
All right, we're going to have a public hearing on Senate Bill 1052 presented by Senator Trent. Please proceed when you're ready. 1052. Sorry. I'm confused. Senator, please proceed.
Thank you, Mr. Chairman, members of the committee. Curtis Trent, representing Senate District 20. This is the 1052 is the workers' comp fee schedule bill. It's actually a very short bill. If you look on page 3, that is the majority of the changed language that's in the document. There's a little bit on page 9 as well. But essentially, what we're doing here is allowing the division to establish by rule a schedule of fees for any service provided pursuant to this chapter. And what this would mean as a practical matter is that if you look at most other states in the country, Missouri is an outlier, as it often is on these matters, in not having any fee schedules for workers' compensation. This leads to a market increase in cost of both physician fees and facility fees that are ultimately passed on to Missouri businesses and makes our state less competitive. This is not about provision of care. That will still continue to be provided, but it is about controlling the costs that get passed on to businesses and ultimately to every consumer in the state of Missouri. I'd be happy to answer any questions, and I believe we have a slate of witnesses here as well, and only about 15 minutes left to work in the committee today.
Sorry, I forgot I was chairman again. It's like they're going to say anything. Any questions from the committee? Senator McCreary.
I look forward to hearing from the witnesses, but do you have any concerns that, depending on what part of the state the worker is getting care, there's different prices based on access and that kind of thing. So is it you're going for something uniform across the entire state?
Well, the way it's written, we're giving the division pretty wide latitude to promulgate rules to implement this. So I think that is probably something that they could contemplate. At least the language that's before us right now does not change anything to the way that is established right now in terms of the uniformity across the state.
Okay. Yeah, I think my general concern is I'm worried that that it could be set so low that there wouldn't be providers willing to provide care to people. So,
now I think this is just about cost control. Do not envision any shortage or unavailability of care. We want to make sure that folks that are using this system are still able to get the care that they need.
okay, thanks.
Any further questions? All right, seeing none, those in favor of Senate Bill 1052, please come up. Keep your comments brief.
Thank you, Mr. Vice Chair. Hampton Williams with the Missouri Insurance Coalition testifying in support of this bill. What this bill does is standardize reimbursement rates for medical services that are a part of a workers' compensation proceeding or claim. It promotes predictability in what these claims cost, and it allows access to care for the injured workers. What it does not do is limit medically necessary treatment. It doesn't determine what compensability is. That's still handled by the court itself. What we're doing, though, is taking kind of an issue of contention off the docket of these workers' comp judges. Now, they won't have to determine the reasonableness of a fee. Once a fee schedule is set for procedures, that is a number that's plugged in during the proceeding, and then the other elements of the case can proceed. 44 other states have this, as well as the District of Columbia. The last state to implement one was in Virginia 10 years ago. I've got a report that I'm going to submit which will identify the cost disparities between Missouri's and these other states. We're paying about 20% more for services than these other states that have adopted this. So thank you for your time, and I'll be sure to follow up with you later.
Thank you, sir. Any questions for the witness? Seeing none, next witness in favor, please proceed.
Good afternoon. Matthew Smith with Associated Industries of Missouri. Just going on record in support of this bill. I think the senator and the previous witness explained it pretty well, but we do support standardizing the fees and joining the other states in doing this. So happy to answer any questions.
Thank you for testimony. Any questions? Seeing none, next witness in favor, Senate Bill 1052. Seeing none, those against Senate Bill 1052, please come on up.
Mr. Vice Chair, Jacob Scott, representing the Missouri State Medical Association and the Missouri Association of Osteopathic Physicians and Surgeons. On record in opposition to the bill, first I want to thank the sponsor for having a brief conversation with me about our opposition. Really I don't have much to say about it other than we appreciate the law that we currently have. If you turn to page 3, what we're changing here, of course, is allowing the division to establish a schedule of fees. What we're eliminating is the line on page 52 and 53 where it says fair and reasonable. So we like the concept of fair and reasonable, and we share, a few of the concerns like Senator McCreary has, that if, these costs are so low that, they may not get the care that they need. So we like to keep the current law. Happy to work with the sponsor and happy to answer any questions.
All right, thank you for testimony. Any questions? Seeing none, next witness in opposition. Mr. Monsees.
Mr. Chairman, members of the committee, Rob Monses on behalf of the Missouri Hospital Association, testifying in opposition today. Appreciate, again, to echo the sentiments of my colleagues from the physicians. If you take a look at the fiscal note related to this, there was a pretty extensive process of what would have to happen to set these rates, and a pretty hefty note that goes along with it. I understand the desire to keep those workers' comp rates low. We have concerns about that kind of process and keeping up to Senator McCreary's point, keeping up with all the different parts of the state and the varying geographies and all the different kinds of medical providers that are a part of this process. That's a pretty tough thing for a government agency to hit just right. And so we have concerns in that regard. Thank you.
Any questions for this witness? Seeing none, thank you for testimony. Next witness opposition, Senate Bill 1052.
Mr. Chair, members of the committee, Nikki Strong here on behalf of the Missouri Ambulatory Surgery Centers, going on record in support. Echo some of the previous statements made. We have some of the same concerns. We have been talking to the senator and office about how to move forward with this, and we'd be happy to continue those conversations.
Support or
I'm sorry.
opposition?
I say it's support. I'm sorry. Opposition. Thank you. Thank you. I haven't eaten lunch yet.
All the
and
other
it-
medical
and it's like,
associations
it doesn't
are
work.
against it, but-
Yeah. So
You
let me
on
start
camera.
over. Nikki Strong in opposition to
Okay.
on behalf of the Missouri Ambulatory Surgery Center. So yeah.
Thank you for your testimony. Any questions for the
Just wanna
witness
make sure you all
that
were
needs
awake.
lunch? Seeing none, any further witnesses in opposition to Senate Bill 1052? For reminders, we are in opposition. Okay.
Good afternoon, Senators. I'm David Claridge today, appearing in opposition to Senate Bill
opposition to Senate Bill 1052 on behalf of the Missouri Association of Trial Attorneys. As we reviewed the legislation, 287-140, paragraph 3, line 51, refers to all fees authorized under Chapter 287 workers' compensation. We don't understand, we kind of look at the context of that paragraph and see that it is primarily related to fair and reasonable health care costs, and substituting those costs with a general schedule promulgated by a department, the division, of workers' compensation. We don't know whether or not that implicates our ability to recover attorney's fees or our ability to recover under the reasonable costs that are associated with those that we represent who have been hurt on the job. So we've got some questions and concerns about the legislation as drafted, but wanted to express this to you. Plus, I also wanted to testify on the same side as Rob Monses, which I thought would be an outstanding opportunity. So.
It sounds like you all are in agreement on opposition. Thank you for your testimony. Any questions for this witness? Seeing none, thank you, sir. Any further witnesses in opposition? Senate Bill 1052. Informational purposes only. All right, Senator, any closing comments?
No further remarks. Appreciate the committee's consideration.
All right, thank you. That'll conclude the public hearing on Senate Bill 1052. I now make motion to adjourn. It has been seconded. All those in favor say aye. All those opposed, same sign. We are adjourned.